Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. I'm still traveling, which is why we've got the slightly more colorful background today. But traveling means that there's going to be updates in every case I'm following. It's just the nature of things. And one of those cases is Proven Industries versus Trevor McNally. If you're not familiar with this case or you need a quick refresher, this one, Proven Industries makes locks. And so they went on Instagram and they said, hey, our lock is the best. You cannot get into it. Look at all the ways we tried. And then in the comments, somebody said, well, I want to see Trevor McNally try. And they said, he'd never do that. He only goes after the easy ones. Which is, of course, a clear challenge to Trevor McNally, who picks locks for a living. So what does he do? Well, he uses a bit of pop can and he bypasses the lock. He uses the pop can as a shim. And so now Proven Industries has an even bigger PR problem on their hands, so they decide the thing to do is to publicly insult Trevor McNally, but also to sue him. Which, if you know anything about the internet and how it works, is pretty much the worst option they could take. But that's how they roll. They like the bad way to do things. So, the latest updates, well, they dismissed their case. I already covered that. And since then, there have been 2 new filings. And the reason why is because when Proven Industries dismissed their case, they said, but we still, Judge, want you to hear the sealing order. We've requested to seal all of the documents in this case. Now, 2 motions have been filed in opposition to that sealing order. One of them is well written, and the other one is mine. And we're going to go through both, but we're going to start with the well-written one. So let's dive right in. I guess this is, both of them are highly entertaining. At least I think. I don't know if I can say my own is entertaining. Theirs is entertaining. Mine, you will have to decide. So here we go. So Proven Industries versus Trevor McNally. We have defendant's opposition to plaintiff's motion to seal. So defendant Trevor McNally files the stuff and information and background. Proven Industries asked this court to seal nearly every document in this case. That is a correct statement of what they've asked for. This extraordinary request, filed only after the court denied Proven's emergency motion for preliminary injunction, is an improper attempt by Proven to shield its failed legal strategy from the public. And I'm pretty sure that if the court had actually granted their motion for a preliminary injunction, and if the court had been spicy towards Trevor McNally, then they probably would have said, well, let's leave that in the public domain, but they didn't. So there's no basis to seal any of the documents in this case, and Proven's motion should be denied. Proven is a lock manufacturer that frequently promotes its product through social media. After publishing a promotional video about one of its locks, Proven publicly challenged McNally, suggesting he could not open the lock. McNally, in response, published a video in which he bypassed Proven's lock with an aluminum can in a matter of seconds. Rather than address the flaws in its product, Proven publicly attacked McNally on social media and filed this lawsuit. One of the most important functions of a lawyer sometimes is to tell you when not to hire a lawyer. A good lawyer will say, you don't need me here, or you don't want me here, or more importantly, you're going to make things worse. And Proven Industries managed to find a lawyer who did not tell them that he was going to make things worse, and then they proceeded to make things worse. This is not a lawyer problem. This is a hire more engineers. This is, fire your lawyer, hire another engineer, because what you should do in response to something like this, if you're Proven Industries, is fix the problem and then address that, hey, it sucks that we had this big problem with our, locks. We're really disappointed. We thought we had a great product, but turns out this guy awesomely showed that, it is an awesome thing when somebody shows you that your product has a critical flaw. This guy showed us that we don't. So we fixed it. And here's the fix we're rolling out. Like, that's how you win over hearts and minds here. And that's not what they did. They went the other way. In the early stages of this case, Proven had no qualms about making this dispute public. Proven boasted to its social media followers about how it sued McNally and how confident it was that it would prevail. Proven even encouraged people to search for the lawsuit. We have filed a lawsuit and will be exposing him. Look up Proven versus McNally. Check out the formal filing. Well, we sure did, folks. We've been checking them out, and I am actually glad they encouraged this, because going over some of their filings is some of the best fun I've had in the last little bit. It's been highly entertaining. But I'm not sure that I would have adopted that strategy. But when you think of like filing something under seal, this is the opposite of that, right? Filing it under press release? Yeah. So, on June 2nd, Proven filed its emergency motion for preliminary injunction motion, along with multiple declarations. If I recall correctly, that's actually what they titled it, the emergency motion for preliminary injunction motion. But I may be misremembering. Along with multiple declarations and numerous exhibits. Although Proven now claims the motion and the documents it filed disclose sensitive and confidential business information and other additional sensitive information, Proven did not attempt to seal these matters prior to filing them. And the other thing they haven't done and still haven't done is sometimes people oops, right? Sometimes you file something, you meant to file it under seal, and you go, oops, my bad. I just realized we filed this on the public docket. And the court is not unfamiliar with this. If they called up the clerk's office and were like, that was supposed to be under seal, please remove, please remove, please remove, the clerk would be like, yeah, okay, but, file it right and file that immediately. This is not the first time this has happened to somebody. But they didn't do that. And more importantly, even when they applied to seal now, they didn't say that it was filed unsealed because of an inadvertent error. If they'd said, listen, this was an inadvertent error and, we never meant to file it publicly, well, then I might have had an ethical obligation to respect that. But they didn't. They just said, oh, well, now we regret it. And there is, now we regret it is not a time machine, right? You can't necessarily go back because you regret something. So, on June 6, 2025, McNally filed his response, and on June 10th, Proven filed a response along with another declaration. Proven did not seek to file its reply or supplemental declaration under seal, nor did it ask for McNally's response to be sealed. So, on June 13th, the court held the preliminary injunction hearing, during which Proven never raised confidentiality concerns, never requested sealing, and never suggested that any information disclosed in court or in any of the filings required protection from public disclosure. Now, I'm going to call this out because I actually think this is wrong. I think that there's an error in here. Because Proven did actually object with one particular document. There was one document where they said, listen, we would file this, but there are some concerns, there are some names in it and so forth, so we're trying to file a redacted version. And the court said, well, you also need to file like a true copy, like that has to be done. But they did raise confidentiality concerns with one specific document. But what they didn't do is they didn't say this hearing is going to have to be sealed. They didn't say, like the hearing as a whole. They didn't say there's been a lot of documents filed and those need to be redacted and those need, none of that happened. But they did raise one thing. And I actually think that this error makes Trevor McNally's argument stronger, because it's not just that they forgot, it's they raised issues with one document and none of the other documents that they had filed. So they did actually think about it. They just didn't ask for any of the relief that they only asked for after they lost, and people made fun of them. Yeah, okay. At the conclusion of the hearing, the court denied Proven's motion for preliminary injunction. Only after the court denied Proven's motion for preliminary injunction did Proven suddenly discover a need for secrecy. Now, this is interesting, because I doubt they would have asked, and this is just my guess, right? I don't know, but I doubt they would have asked for the sealing order if they'd gotten the preliminary injunction, because the preliminary injunction would have been a one-sided gag. It would have said, okay, Trevor McNally, Trevor McNally, you can't talk about this, but we can. And it would have actually given Proven the ability to beat up on Trevor McNally without him being able to respond. And in doing so, they could have used the court documents and the transcript and all of that fun stuff. But after they don't get that, then suddenly it's like, well, everything needs to be kept secret. And that's partially also, I'm sure, because Proven Industries did not come off well in that interaction, because, they weren't able to tell the court, listen, this is a shim-proof lock. You cannot shim it. In fact, they were in a position of telling the court, listen, our engineer, who has never done any lockpicking before, was able to shim it. Eventually, after watching Trevor McNally's videos. So, yeah. On June 20th, 2020, by the way, I'm sure he appreciates the views. On June 20th, 2025, Proven filed its motion asking the court to seal almost every document in the case, including the preliminary injunction order and documents that Proven chose to file in the public domain. Approximately 2 weeks later, Proven decided to dismiss the case, but nevertheless asked the court to rule on its pending motion to seal. As evidenced by the fact that Proven never sought to seal anything in this case until after the court denied its motion for preliminary injunction, Proven's true motivation for filing its motion to seal is not to protect sensitive information, but rather to hide from the public any trace of the preliminary injunction proceedings. And, quite frankly, I think the sensitive information they're trying to protect right now is just how badly they got clowned. Memorandum of Law. Proven filed a notice of voluntary dismissal, and its motion to seal is moot. So what does it mean for something to be moot? Well, moot is basically that it is now irrelevant. So as an example of something that might be moot is, let's say the government charges Bob with murder. Bob has been accused of murder most foul. And then Bob trips and falls into a combine harvester and dies. So now the proceedings against Bob are moot because we're not going to take the combine harvester bits and put them in jail, right? I've actually had an example of mootness in a case that was me personally. I was fighting the government to get a particular thing added to my firearms license, and then the law changed and required that every single person get that thing added to their firearms license. And it's like, well, now my application to force them to do it is moot because they have to do it. So we don't need to fight about this anymore because they have to do it. So, yeah. In this case, their motion to seal is moot because they dismissed the case. So we'll see the argument here. A plaintiff's voluntary dismissal under the rules is effective immediately. Stops things, full stop, right? And they cite case law here, which you'll see is something that not everybody does. It is also self-executing and moots all pending motions. Thus, when Proven filed its notice of voluntary dismissal, this case concluded and Proven's pending motion to seal was rendered moot. Accordingly, Proven's motion to seal should be denied. And I think Proven could actually have easily avoided this issue by just sending a notice to the court, like a letter to the court and other parties, basically saying, we're not dismissing it, but we intend to dismiss it as soon as the mootness, or as soon as the motion to seal is dealt with. That would have been the better way to do it. The court may still hear this motion to seal, though. They do have some discretion, but this is a good argument, because if the judge wants, A, it's a good argument just inherently, but B, it's also a great argument to include because if the judge just wants to make this go away without actually having to dig into any of this stuff, the judge can just say, yeah, it's moot, and issue a one-line ruling. Just here's an order. It just says, Proven's motion to seal the documents is denied as moot. Done. And that may well be what we see. So, and I hope not though, because I hope we get a full discussion of this because it would be funnier. Proven's motion to seal should be denied because it fails to establish good cause sufficient to rebut the presumption of public access. Both Canada and the US have public courts, right? You can go in and sit in on court proceedings, even pretty serious ones. Like if you want to watch a murder trial, you can do that. It used to be you'd do that by walking in and sitting your butt down on the very uncomfortable pew and then watching the trial. Now, often you can do that via, YouTube and so forth. So that's the presumption, is that that the public will be able to see things. And you have to have a reason not to. Now, sometimes there can be very good reasons. Let's say I am the Coca-Cola Corporation, notable for its manufacture of fine shimming material, which also contains a liquid that people also drink. And the recipe for Coca-Cola is a very closely guarded secret. So, let's say they have an employee who, leaves and tries to sell the secret recipe to somebody. And one of the issues that would, of course, come up is whether the recipe they were selling is, in fact, the real recipe or a fake recipe. But Coke would certainly want it to be sealed that the recipe that they were selling is the real way to make Coke, because the only protection that has is that it's secret. And the public can judge this, like that hypothetical case. They can analyze it just by virtue of like the facts around it. They don't really need the recipe themselves in order to judge the merit of the case. So the court would be virtually certain that they would seal that. All right. So, but I also imagine that Coke's lawyers would have been good enough to file the motion to seal before they put things into the public domain, because you can't, you can't fix that. Just like Bob in the Combine Harvester, you had your chance and then it's done. All right, so even if Proven's motion to seal is not moot, it should still be denied because Proven has failed to demonstrate a sufficient basis to overcome the presumption of public access to the judicial proceedings. Once a matter is brought before a court for resolution, it is no longer solely the party's case, but also the public's case. And they cite case law. There is a presumptive common law right of access to judicial proceedings and to inspect and copy judicial records. And they cite Chicago Tribune versus Bridgestone. And I'll talk about that too. The common law right of access is an essential component of our system of justice and is instrumental in securing the integrity of the process. The presumption of public access is echoed by this court's local rules. Although the public's right of access is not absolute, Proven has failed to demonstrate that good cause sufficient to overcome the presumption for at least 3 different reasons. Let's also talk about why this presumption exists. A lot of stuff in the US exists because of the experience the US had being a colony of Britain. And Britain did not always treat its colonies very nicely. I think they're actually kind of famous for that. So, one of the things that they did a lot was they had secret trials. And so let's say, Bob, like historical Bob in like a, old-timey hat and so forth, is arrested off the street and they say he was poaching, which used to be a serious crime. Like they would kill you for poaching and that kind of thing. So they pull Bob off the street. They say, Bob, you are a poacher. And he gets dragged into a courthouse and they shut the door and they post like the 2 beefiest colonial era guys at the front, of this courthouse. And then sometime later they come out and they execute Bob and they say Bob was convicted of poaching. And everyone goes, Bob is not a poacher. How would Bob have even poached? Bob is blind or something, right? And people would be skeptical of these court results because how do you know what happened if nobody can see it? So because of that, the whole thing of like public trials has been an important thing for a good long time. You know, you don't want to have all of these issues, and public trials are the way to avoid it. Even if Bob eventually gets punished, at least then the public can see it and go, yeah, it turns out Bob really was a jerk. So, yeah. All right. First, any attempt by Proven to demonstrate good cause is belied by its actions leading up to the preliminary injunction hearing. Proven is the party that filed this lawsuit and then boasted about it on social media and encouraged people to search for the case. Proven was aware of and even encouraged the public interest in this case and still filed numerous documents in the public record without making any effort to file them under seal, right? It's not that they were surprised there was public interest. In fact, they were suing because of the public interest, but Proven Industries specifically directed people to the case. They were so sure that they were going to win handily that they were like, go look at this case. And even with all of that in mind, they didn't file anything under seal. So, you know, it's not like you didn't know. It's one thing if you fall into a pit and get bitten by a snake, you know, then you're like, okay, well, that's really tragic. It's another thing if you walk up to the snake and start backhanding it, and then the snake bites you. It's like, well, you knew it was a snake when you started backhanding it. Okay. If these materials were truly sensitive, as Proven claims, Proven would have or should have moved to seal them before filing. I mean, Proven's best argument here would have been if they argued something like, listen, our lawyer is a mushroom and has never run a case before, and, you know, his bad. But they didn't do that. In fact, I think they're saying he's extremely experienced counsel and should know better. So it was only after the court denied Proven's motion for preliminary injunction that it sought to have these proceedings shielded from the public. Proven has not provided the court with any explanation about why it's never sought to file its documents under seal, nor why it waited until the court denied its motion for preliminary injunction to file its motion to seal. By the way, this is a little trick that lawyers do, and it's a good trick. Lawyers are not going to stop doing it anytime soon. It's not an unethical trick. When I say a trick, it's like a trick like throwing a fastball, not a trick like, using some sort of rigged baseball or the like. I need to avoid the sports metaphors. Moving on. So, this is sort of a technique. And basically what they're inviting the court to do. They say Proven has not provided the court with any explanation. They're inviting the court to say, well, Proven, why? Explain this. And the reason why you do this as a lawyer is when you think the other side can't explain it. When you think that Proven's attempt to explain it is likely to be hilarious and embarrassing. That's why you do this. So, I suspect that's where they're going. All right. Shielding a party from the litigation consequences of its own activities is not a value to be served by allowing documents to be filed under seal. And they have case law for this, which is excellent, even though it should be fairly self-evident. So, second, the documents Proven asked the court to seal have been publicly available for weeks, and therefore should not be sealed. So, and they cite more case law to a party should not seek to seal information that is already public. Moreover, a YouTube content creator, has published videos discussing this case, including depicting some of the documents in this case, which have received approximately 700,000 total views. That's me. I'm the YouTube content creator. And they actually cite to a document that's been filed in the case. We'll talk about that. Because the documents have been accessible in the public domain for weeks and the subject of public discussion, there is no rational basis to now seal these documents. And I'm sure that the rational basis is just this makes us look really bad. Third, Proven does not identify the specific information contained in the documents that it claims is sensitive. And that's probably because the information that they claim is sensitive is actually super boring and uninteresting. But similarly, Proven does not explain how sealing nearly every document in this case would protect Proven from the harm it claims it is suffering. Instead, Proven speculates this case will be used by McNally's social media followers to harass Proven, but fails to provide any explanation as to how that might occur. And again, reminder, do not harass any human. It's just a party foul. So, in fact, according to Proven, much of this alleged harassment occurred before the case was even filed. And it is sort of a very simple rule of causality that generally the cause must happen first and the effect happens afterwards. Because if the cause happens second and the effect happens before it, then you have invented some sort of time machine and you should run really hard to the patent office to get that squared away before somebody else does. Because or maybe don't get it squared away and maybe just like go back and, buy Bitcoin and shoot Hitler. So, and not necessarily in that order. You could do it the other way around if you wanted. All right. So, and then there's a footnote, and footnotes are often fun. Proven references certain marketing and revenue related information that it characterizes as confidential business information. But again, Proven previously filed these documents in the public record without seeking any protection. If it was confidential, you'd think you would have asked to seal it beforehand, right? Not after. Moreover, Proven fails to explain how the information is confidential or how it would adversely affect or impact Proven if it remains public. Proven's generic boilerplate descriptions of potential harm are insufficient. So then we have, thus, Proven has not and cannot demonstrate that sealing the documents it has identified will prevent the harm it claims it will suffer. This is a much better way of writing this than some other jerk who we'll see soon. Proven has not demonstrated good cause to overcome the strong presumption of public access to this case, and its motion to seal should be denied. So, we also have Proven's motion to seal should be denied because it fails to establish why it is necessary to seal nearly the entire record in this case. Normally, you're more likely to get like sealing or whatever as a remedy if you're doing it in a targeted fashion, right? In my hypothetical Coke lawsuit before, you might say, listen, we have to seal the 3 documents, right? This document, which is the original recipe that we're filing, but it's got to be sealed. And then this other document that is the recipe, like the handwritten one that we found on the guy who stole the recipe. And we also want to seal this filed police report, which also details the recipe, right? We want to seal those specific things, not everything, right? We don't want to you can't seal something just because it mentions that the recipe exists, for example. So the more targeted you are, the more you're using a scalpel, the more likely the court is going to approve it. They're like, scalpels, yes, chainsaw, no. And yeah, this is Proven as wielding chainsaws is basically the point here. So, local rule requires that Proven establish that sealing the item is necessary. Here, Proven asks the court to seal nearly every document in this case without identifying the specific information contained in each document that substantiates its purported basis to seal, and without explaining how sealing any of these documents would protect Proven from the harm it is purportedly suffering. Proven's failure to identify the specific information and corresponding basis to seal each document demonstrate that it is not concerned about protecting sensitive information, but instead is trying to hide the preliminary injunction proceedings from the public. This is further exemplified by some of the materials Proven seeks to have sealed. For example, Proven asked the court to seal the court's order setting the preliminary injunction briefing schedule and the corresponding notice of hearing. Now, Proven's main basis for all of this is based on harassment. And at this point, they're basically saying that the court must have been filing documents that would assist in harassment because these are just court documents, right? They're not any information from Proven or even from McNally. It's from the court. Yeah. These are procedural documents issued by the court that do not contain any sensitive or confidential information. Nevertheless, Proven apparently wants them sealed. As another example, Proven asked the court to seal a document, even though that same document is attached as an exhibit to its complaint, which Proven is not seeking to seal. Okay. That's funny. I didn't notice that. And they're like, we want to seal copy A of the document, but copy B of the document can remain in the public. And this is supposed to make sense. This is also why, as a lawyer, you want to be wielding a scalpel, because you look like an idiot when you say you're doing surgery, but in fact you're doing chainsaw massacre. So in short, there's no basis to seal any document in this case, let alone nearly every document as Proven requests. Because Proven fails to sufficiently explain why it is necessary to seal each document, Proven has failed to meet the standard established by local rule, and its motion should be denied. So, and they cite to case law, finding that plaintiff's motion failed to satisfy the requirements of local rule, in part because plaintiff points to no specific information contained in any of the documents that poses a threat to plaintiff's personal safety or otherwise should be kept confidential. Yeah. Proven's motion should be denied because it fails to establish that using redaction or a means other than sealing is unavailable or unsatisfactory. So this is another thing that the rule requires consideration of, and also illustrates that the rule itself is very much intended to promote the scalpel and not the chainsaw, because in order to get a sealing order, they say, listen, you have to show that you can't just redact something. So, let's say you've got a document that includes the secret recipe for Coke, and, it might be like, well, could we just take a Sharpie and blot out the secret recipe, but still have the rest of the document available to the public? Because if that works, then that's the appropriate remedy, right? If the only issue is you don't want to reveal the name of a specific person, you just redact that part out and the rest of the document can go in, usually. So, Proven makes a generic claim that redactions are insufficient, but it fails to provide any legitimate explanation as to why. Instead, Proven resorts to a blanket assertion that, even with redactions, the document in this case would reveal contextual information that could somehow be weaponized by unknown third parties to harm Proven. Proven's conclusory claims are insufficient to establish that sealing is appropriate under Local Rule 1.11, and its motion should be denied. So, conclusion, for the reasons stated above, the court should deny Proven's motion to seal. All right, that is very well written. That, I think that is excellent work. And so now we're going to read some less excellent work, which is, of course, mine. And before you say, oh, Runkle, you're being too modest, I just want to note here, this was written somewhat in a rush. And in fact, it was, not only is this not my best work, it's not even my best work on this specific motion. Because I'm traveling, and I wrote a draft of this motion that included things like references to case law, which you would normally expect in a motion. And then I forgot to save that in like a place where I could access it. Like I didn't send it to my, Gmail account. I didn't send it to Dropbox. I didn't put it on a drive. I didn't put it on OneDrive. I didn't any of this stuff. So, yeah, I'm in another city, and it's not only like on my computer, but it's on my computer, which is, locked down and all of that. So I don't have access to it, which means that I had to sort of start again. And I was also at a conference, so I did not have the time or ability to go and research citations. It's also a little more difficult as a foreign lawyer because I don't have access to like the US Westlaw. I've got access to Canadian Westlaw, but not US Westlaw, which means that in order to get proper search access, I would have had to pay like ridiculous amounts in subscriptions. Lawyers get gouged on this stuff, but I wasn't down to do that. And so I'd research case law kind of the dumb way, which is by looking at other people's filings and going, oh, right, that case makes sense. And the other side didn't say it's stupid. And I can also find the case when I look it up. So it's not like a ChatGPT hallucination, because that would be even more embarrassing to steal somebody else's ChatGPT hallucination. So yeah, anyway, I am being long and rambly to say My filing kind of sucks, and I know it, but it is what it is. So, without further ado, the filing that sucks. Here we go. Yes, I am great at introducing things. So, Proven Industries Incorporated versus Trevor McNally, non-party Ian Runkle's opposition to motion to seal under Local Rule 1.11. Now you might be saying, wait, Runkle, how do you get into this case at all? As a non-party, like you specifically identify you've got no business being here. Well, the reason why is because the Local Rule 1.11 actually allows for not just parties to oppose it, but also non-parties. And the main reason for that is because the media exists, right? There is freedom of the press, there's all of those things. And so when you think about who might oppose a sealing order, well, the media is probably the one that immediately leaps out. So what do I begin with? Well, I begin with, hey, I am, media, because I kind of am. It's weird, but I am. So, introduction. This is a case that plaintiff, Proven Industries, has brought due to the national and international attention. It's me, I'm international. It had already invited to its dispute with a very high-profile content creator. Having succeeded only in adding more negative attention to the problems with their locks that it wished to hide, Proven Industries now seeks to shut down the public discourse it invited around its court filings. I will also say this is not... after I got this version done, I ran it past a friend who told me I needed to tone it down because my initial version was spicier than this. And so this is like, the original one was like extra spicy. This one is like medium spicy. I don't really do like fully mild. That's not how I roll, but yeah. All right, so let's see how I describe myself, which is actually kind of weird to do in a court filing, but it is what it is. Mr. Runkle is a Canadian lawyer who does legal commentary on YouTube and elsewhere, discussing both Canadian and American legal cases with a mixture of humor and educational content, making legal commentary accessible to the general public, although his viewer base includes a large number of legal professionals in both countries as well. Mr. Runkle is accredited media in the Alberta courts. True. He has also won awards for his content and has received government grants to produce content. I have yet to actually produce the content that I have a grant for, but I need to get off my butt for that because I think the deadline is coming up. So, to date, his channel has over 38 million views, 12.1 million hours of total watch time, and over 300,000 subscribers. This case is of substantial interest to the public, including Mr. Runkle's viewers. Mr. Runkle has created 4 videos on this topic thus far, so I guess this makes it 5, which have a total viewership of approximately 700,000 total views. Mr. Runkle's commentary on this topic has already been mentioned in this case as a potential exhibit, as was a viewer comment on Mr. Runkle's commentary, and I cite to that. Now, this is about like the only citation is just citing to within the case, but yeah, I didn't really lawyer this very much. It's mostly just argument. So there is substantial public interest in this matter and in continued coverage of this matter. I hope people are going to watch this, that I'm not just talking to the void, but even if I am just talking into the void, this case makes me laugh, and so I'm going to continue covering it because there is precious little joy in the world, and so everywhere we can find some, let's go ahead and do that. So notwithstanding that plaintiff has now filed a voluntary dismissal without prejudice, they still seek a ruling on the motion to seal. Therefore, the court should also consider this timely filed opposition. I.e., if you're going to hear their motion to seal, you should also hear my opposition to their motion to seal. Necessity of filing the items. So one of the parts of the test for sealing something is, was it necessary to file it in the first place? If it wasn't necessary to file it in the first place, maybe it shouldn't be sealed. Maybe instead it should just be rejected. Maybe all of those things. And yeah. Okay. So all of the listed items in plaintiff's motion, other than the transcript, were filed not under seal and have been public record in the intervening time. During that time, they have been downloaded by many individuals, including Mr. Runkle. That's me. It's still weird writing in the third person, but they have been publicly hosted on courtlistener.com, where they will remain even if the documents have been sealed. There's a number of cases where the documents have been sealed and Court Listener has kept the original documents up. Certainly, plaintiff was aware that there was a strong public discourse around these issues. It is in fact the primary basis of their legal action. Like, you're suing for defamation because you're saying that there are millions of views of videos that you are unhappy with. You knew the public was paying attention, right? Come on, guys. This is not news to you. This is not a surprise. It's not like you're, Joe Boggs versus, Bob Smith suing over like the price of widgets and then are suddenly shocked that the public cares deeply about widget prices. No, you knew this was huge public interest. Plaintiff, while represented by experienced counsel, nonetheless elected to file its pleadings, including the personal and business information it now seeks to protect, not under seal. Plaintiff elected not to use the proper procedures to prevent public disclosure of this information. They also do not allege that this was inadvertent error or a filing mistake, suggesting that it was intentional. Like, if you filed this publicly on purpose, then the answer is live with your mistakes. We're citing to the legal case, not actually, because I didn't cite any case law, but we're citing to the principle of fuck around versus find out. And right now, find out is doing a lot of winning in this case. It is difficult to see what has changed to make it necessary to seal these documents that was not necessary at the time they were filed. Like, if you didn't think they were needed to be filed under seal at the time, what happened? Oh, you lost? That's not a reason. Further, plaintiff's own filings indicate that the negative effects of the public release of this information have already occurred. A line that I cut was basically that Proven doesn't need a sealing order, they need a time machine and better judgment. And that line got cut because it was maybe like extra spicy instead of medium spicy, but it's true. Proven's problem here is one that can only be solved with a time machine and some better decision making in the past. Like, just the time machine alone is not enough because Proven Industries have shown that they are very dumb, and given the time machine would probably go back and do the dumb thing exactly the same way. It is difficult to see what has changed to make it necessary to seal those documents. Oh, right. In every way possible, this is a bell that cannot be unrung. There's other metaphors, but I didn't want to file them in court. All of the documents that plaintiff seeks to seal have been widely published and accessible in downloadable format. Several of the documents have been reported on, including by Mr. Runkle, as part of the public discourse initiated by plaintiff. So, it's me. I've reported on these. And also, when you see that in the better written filing, they were like, hey, some YouTube guy has already, had 700,000 views. They cite to me. I'm the YouTube guy that had 700,000 views. So I guess I'm now like evidence in this, which is weird to me, but there we are. Further, the documents are available on sites that are far more accessible to the public than the official record accessed by a pacer. Other sites offer access that does not require a login and where the documents are available free of charge, such as, for instance, courtlistener.com. Plaintiff, having chosen to file these materials publicly and being unhappy about the results of that decision, now seeks redress that is simply not possible, to have made a different tactical decision in the first place. Yeah, court can't fix your problems because your problems are big problems. Yeah, if you get your southern parts caught in the zipper, sure, you can't undo that without a time machine, right? You might wish you had not done that, but wishing ain't gonna solve it. Sometimes you just gotta live with the choices you've made, and yeah. Simply put, it cannot be necessary to seal the documents where sealing them will bring no relief. It cannot be necessary to close the barn door once the horse has already escaped. This is also a place where some judicious editing was applied, because the original version of this was to say it cannot be necessary to close the barn door once the horse has already escaped and wandered into traffic. I was told, metaphor a little too spicy. And I mean, I say this like, oh, they're a killjoy. They're 100% correct that this is the better version for filing, but I still like the original, and I'm going to pout a little bit. So, of all the documents identified by plaintiff as ones that they seek to have sealed, the only document yet to be posted to courtlistener.com is this court's own decision. The open courts principles suggest that this must be made available. The decision of the court is known, but the basis for the decision is important for the public's ability to understand it and to recognize the fairness and the appropriateness of the reasoning that led to it. By the way, this isn't just me like puffing the judge up. I mean, there is probably a little bit of that, but the judge was very, very good. I like this judge a lot. And, I actually think that the public seeing... We've had some cases that we've covered where the judging was not so good, right? And I really like this judge because it's very clear she has no time for anyone's bullshit. She's just like, we're going to get stuff done. It's going to be reasonable. It's going to be appropriate. It's going to be properly reasoned. Like, we're judging here. And I actually like that you guys are getting an example of like, this is a judge who's just moving their court along and yeah. And it means like when the public can see the judicial decision making in it, it means that like somebody with hurt feelings can't be like, oh, well, that's just a bad judge, right? Let's say Proven Industries is like, oh, this judge was very unfair, very mean to us. No, they weren't. The judge was as fair as you could be, and in fact starts the hearing off by giving grief to Trevor McNally. Like right at the outset, it's like, Mr. McNally, do the demo. It's like, judge, not our burden, right? Judge is like, but do the demo. I want to see you do the demo. You say you can do this. Show me. How can they claim, if they haven't claimed yet, but how could they claim that it's unfair in the face of the full context? So it's important. All right, Mr. Runkle's audience and the audience of other legal commentators are highly interested in the court's rationale. Coverage of the court's analysis serves an important role in educating the public on the legal process and the matters specifically at issue here in a far more in-depth and accurate manner than is possible with only the holding, but not the full opinion. Mr. Runkle's audience watches his coverage precisely because they want to review the facts and filings in depth rather than in 30-second sound bites. And I mean, I always apologize because my videos this one's going to end up being an hour or something as well. And I get people going, well, we like this is the thing is people click on one of my videos and they see that it's like an hour or 2 hours or whatever. And they either click screw that, or they stick around. They're like, hey, let's learn some things. And I'm really bad at doing short videos because I want to get into the stuff. I find it all to be super interesting. It's not as interesting when I'm covering my own stuff because I already know what's in it. And it also kind of feels like I'm like smelling my own farts here in the sense that, it's like, all right, of all the egotistical things to be covering, here's my own filing. But I assume you guys probably don't want me to just skip it for that reason. So, but yeah, there is an appetite for people to get like in-depth real coverage, which is unlike what you typically get in the news media. News media is typically like, oh yeah, there was a court case and like some stuff happened, but we really need more room for commercials. So I'm going to keep this to under 30 seconds. That's not how I roll. So, and if you're still watching 49 minutes in, that's probably not how you roll either. So further, the fact that every document is, as of this writing, commonly available except the transcript, and now the transcript is too, because I published that. It's in a link on the description of my last video. So if you check that out, you can see the like the transcript's there, but if they do get the sealing order, I'll pull it down. I don't think that's going to happen, but if they do, then I will. Yeah, but right now there's no sealing order. There's nothing that says I can't publish it, so it's published. Suggests that the purpose is not to protect the past named witnesses, but that instead the goal is to shield proven industries from criticism and commentary derived from their own arguments and admissions. The big thing is the things they admitted in court or that their witnesses gave away, because they gave away like the entire thing. All right, carrying on. A transcript is an unlikely weapon for harassment. There does not appear to be any names or contact information that is revealed in the transcript that were not previously already made public. A harasser requires no transcript. They can resort to insults and slurs and threats. While the plaintiff is concerned that the individuals might take statements out of context from the transcript, the cure for this is not to hide the transcript, but instead to reveal it so that the context can be checked and the public can examine falsehoods for themselves and uncover the full truth. Like, I get occasional death threats and so forth, and I have yet to get a death threat in the form of a transcript. I mean, it might happen at some point, but it'll probably be somebody threatening to kill me in a court proceeding, and that's why it's in a transcript. But, I mean, people don't harass me with transcripts. It's not how they roll. And when they're saying people might take things out of context, well, the real, like, the solution for things out of context is the full context. And in fact, the sealing order would worsen that problem, right? Because then you've got, somebody can say, well, this is what happened without giving the full context of it, and nobody can check it. So when they say we're worried about out of context statements, sure you are. Because if you were actually worried about out of context statements, you'd want the context. Nothing argued by the defendant is fodder for harassment. Rather, the concern appears to be that there would be quotations of admissions made by plaintiffs or their witnesses, as well as the court's own rulings and commentary. That is what I think they wanted to, hide off, is just the things that they said. While the harassment experienced by various individuals is regrettable and is in no way condoned, it is also clear from plaintiff's complaint that the harassment predates any of the materials being filed in this matter, i.e., you're suing because of the harassment, so the harassment wasn't caused by the legal filings. All right, moving on to redaction or pseudonyms would be sufficient, i.e., you shouldn't get to seal everything, because if you needed to, you could just redact out names and stuff like that. So plaintiff indicates that redaction or pseudonyms are insufficient, but their arguments are self-defeating. They indicate that this case has already been publicly identified with the named parties. That was their choice and was entirely within their control. Plaintiffs were represented by experienced and capable counsel at the time they made these tactical decisions. And you might be saying, why am I talking about how great their lawyers are? Well, I don't think their lawyers are all that great, but they are experienced and they are capable, and they made these decisions, right? Nobody has argued, like if Proven came in and said, hey, listen, we need these under seal because we hired the worst lawyers, and these lawyers were total screw-ups, and they filed this stuff publicly, and that's how we know they're screw-ups, and I don't think that's actually true. I don't think there was actually a basis for filing things under seal at the outset, but they haven't argued that, and certainly I don't have any evidence of that. So they're you've got lawyers. It's not that you did this as some self-represented individual wandered into court and is like, hey judge, I did an oops and I need a mulligan. It's not where we are. We're at, you had good lawyers. They should be expected to do good lawyer things, and all indications are that they were doing good lawyer things, other than telling their client that this case was, I don't even know that they told their client their case was worth bringing, because it might be they were like, hey, I'll take your money, but you might as well just have a bonfire with it in the backyard. All right, they state that redaction would not be effective because social media followers have already contacted Ronald Lee's girlfriend and mother. Mr. Lee specifically identified his girlfriend in prior filings. And plaintiff indicates that they contacted Mr. McNally's wife, who certainly was not identified in a filing, i.e., people don't need this material to figure out who your girlfriend is, to figure out who your mother is, and you didn't need it to figure out Mr. McNally's wife's information. Also, party foul, dudes. But yeah, if plaintiff and social media followers are able to identify family members both when they are named in filed materials and when they are not, then that would undermine the claim of necessity of filing under seal. I.e., the public doesn't care. The public can find things. The public can do research. Despite being aware of and fueling the public interest in this case, plaintiff made the decision not to file these documents under seal or with redactions. Had they made the decision to initially file redacted documents, that would have been sufficient. They didn't have to reveal his girlfriend's name, right? All of the people who they're like, we revealed their name. It's like, you could have just not done that. That would have been a good move to not do that, but you did that. Plaintiff now requests the court save it from its own choices by hiding the court's opinion and removing public access to the official public records, which are widely available from unofficial sources. Redaction would have been sufficient from the outset, or the use of pseudonyms for individuals connected to the matter. Certainly, plaintiff indicates that a potential witness asked, "Is there a way to leave my name and my company's name out of this?" And there is. You redact the name, and you redact the company name. Like, the witness specifically said, hey, could you leave my name out of it? And they're like, nah, we've never heard of that. But if they just redacted it, then that's exactly what the witness was asking for. Suggesting that the witness would have been entirely comfortable if their name was redacted from the materials or if they'd been identified by a pseudonym. They note that another witness, Anthony Bonfiglio, was reluctant to sign a declaration, but ultimately did so, and it was filed without being under seal, redaction, or any other protection, suggesting that in his case it was unnecessary. I'm just going to note here, witnesses are reluctant all the time. Like, all the time, witnesses are reluctant. If I am representing Bob, and Bob is accused of, I don't know, Bob is accused of, New Coke, right? He's the guy responsible for that whole fiasco. A witness that might be helpful to Bob might be reluctant to be seen to be on Bob's side, right? But we have tools for that. We subpoena people. All of these things. So if you've got a reluctant witness, that's just part of lawyering. Sometimes there's helpful witnesses who don't want to testify, and you make them. We can do that. That's how the court process works. So, to the extent that the concern is ongoing harm from these materials being available, redaction would be sufficient and maybe more effective than a sealing order. If the documents are sealed, then the only available copies will be the previously public unredacted copies, which are likely to remain readily available. Those seeking out copies of the documents will therefore pursue those that are available unredacted. Like, if you want to get a copy of, let's say you want to get a copy of whatever, like one of the declarations or whatever. You go on to Pacer and you go to pull that and it says, this document has been sealed. Well, you might just plug into Google some things about the case and find the documents somewhere else where they're available unredacted. So, in fact, having redacted copies that are able to compete with the unredacted versions actually might keep the information from spreading somewhat. Yeah, I don't know that they can fix this, but to the extent they can, redaction might actually work better than sealing. So, if the documents are redacted, then those redacted copies exist to be readily distributed and to compete with the unredacted versions, making it more likely that individuals seeking them find a redacted version. The articulated concerns stem entirely around issues of specific people being named. Had these individuals never been named, it's unlikely that these concerns would have arisen. To the extent that it's possible to try to put the genie back in the bottle, or the poop in the horse, Redaction is sufficient. To the extent that redaction is insufficient, a sealing order would also be insufficient. I.e., anything redaction can't fix, sealing can't fix either. So there's no reason to go beyond redaction in this case. So I'm like, hey, I can still cover this if they redact it. Like, I don't need this dude's name. I actually redacted out his girlfriend's name when I covered it, even though he made it public, because I guess I'm nicer to his girlfriend than he is. But yeah, balancing the public interest. There's strong public interest in this case, as demonstrated by the high viewership of content about this case, 700,000 views. That's not nothing. This is in part because both plaintiff and defendant have been very public in airing this, i.e., why do people care about this? Well, because it's been a hugely public fight. Given that it is the plaintiff that is seeking to seal the materials, this opposition will focus on their position, i.e., I'm not going to fight with McNally here because McNally and I agree. This court has heard evidence in the preliminary injunction hearing that the first salvo in this exchange between plaintiff and defendant was the decision by plaintiff to indicate that Mr. McNally would not attempt to pick one of their locks because he only targets easy locks, thus impugning Mr. McNally's ability. You started this fight, guys. And you started it publicly. And when you start the public fight, you should expect that people will want to consider your arguments. They also publicly impugned his character by indicating, in essence, that Mr. McNally was faking his videos and that they would establish this in court. And having said that, we get to see what happens. Having chosen to push the issue in public and explicitly referencing their court proceedings in the process, they now seek to conceal that court proceeding. Given that other than the transcript, every document that the plaintiff seeks to seal has already been publicly available, it is reasonable to conclude that the primary target of the plaintiff's motion is in fact the transcript. That's what they're trying to hide. And they're not doing a great job, but they're trying. They're trying real hard, folks. As previously noted, a transcript is not a likely weapon of harassment. When the plaintiff indicates their concern is that statements made during the preliminary injunction hearing that could be taken out of context or mischaracterized by defendant McNally's social media followers and viewers to further incite harassment of Proven's employees, their family members, or loved ones, it seems far more likely that their concern is that statements made during the preliminary injunction hearing might be ones that Proven may wish to avoid public commentary on, such as their admission that their locks can be shimmed, although with dispute about the degree of effort, skill, etc. involved. Plaintiff should not be able to publicize the trial proceedings as a sword and then turn around and cry foul when the public exercises First Amendment rights to criticize them. Having made the decision to publicly announce their lawsuit, plaintiff cannot now claim there is no public interest in it. The natural consequence of publicity is public commentary from many viewpoints, including those critical of Proven Industries. Conclusion. Non-party Ian Runkle therefore respectfully asks this court to deny the motion to seal. So, yeah, as I said, not my best work, because my best work would have included, like, citations and law. Hey, we're going to do some lawyering. Normally involves some law, and I didn't have any of that in there. I just had, arguments. But I don't think my arguments are crazy, and certainly, I guess the viewership of it was useful to better legal writers than myself, at least on this particular case. I am possibly being overly harsh on myself, but I am unable to read my own legal writing without hating it and hating everything about it. It's just sort of how I roll. So yeah. Anyway, I am very eagerly looking forward to the court's response to this, and I guess to Proven's response. I want to hear what they have to say about, what I had to say and me. I suspect they don't like me very much, but muffin. Yeah. I think, if I was the judge, I would probably just take the easy way out and just be like, this is denied as moot, but maybe she will, maybe she won't. We'll have to see. Anyway, I hope you found this to be interesting or educational. There's a whole bunch of buttons below. All of those are good, except the unsubscribe button. Stay away from that one. Normally, I would also thank my Patreon supporters here, but I also forgot the critical two-factor bits to log into my Patreon account, so we're not doing that today. I also don't have the tail crawl in, so I can't run any of that, but my Patreon is linked below, where I promise to give the shout out to certain levels, and now I'm failing to do that, but it will be in videos once I'm back in town, and the videos I recorded in advance and can yes. So anyway, thank you for watching. Hope this has armed you with knowledge. See you next time.